Hello, my name is Dave Zapponi. I'm CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this community conversation, Better Meetings and the Open Meeting Act. ECHO is a statewide nonprofit association. We are established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items which were sent in advance and are now presented on the screen. Please take this time to review these. We have a large number of HOA attendees today, which usually means a lot of questions. We have 3 ways to handle the questions. Our speakers have agreed to answer a few questions during the presentation. We also will have a shortened Q&A session afterwards. And finally, we will be responding to some questions during the presentation in the Q&A feature. I'll type those in and send those to you. We hope to answer most of your questions in this way, but we may not have time to answer all of them. Please keep your questions general. Questions about specific situations are better answered one-on-one. Please use the Q&A icon, not the chat icon, to ask your questions or make comments. You should use the chat feature to report technical issues and communicate directly with attendees or staff during the webinar. You will find the navigation icons by hovering over the bar at the bottom of the page. Note the chat and Q&A icons are the 2 most used. To help us select the most relevant questions for this audience, please use the thumbs up icon found in the Q&A screen to vote for your favorite questions. And now for our disclaimer. None of what is said during this seminar will or shall be construed as specific legal advice or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or other suitable expert. Please join me in thanking our premier sponsor, Kevin Boland Insurance Agency, and our Q&A sponsors, CID Consortium LLC and Hughes Gill Cochran Tinetti PC. Now for a short video from the Kevin Boland Insurance Agency. Connor?
Hi everyone, my name is Kevin Boland and I'm a local farmers insurance agent, and my office is located in downtown Novato in the San Francisco Bay Area. So I cannot believe that our lakes and our reservoirs are filling up with water this year. It's amazing to see, isn't it? And I really sincerely hope this will bode well to mitigate our risk of wildfires in California this year. So I'm really proud and happy to say this will be my 6th year of actively being engaged in and sponsoring our ECHO educational meetings. My hardworking team and I have been managing insurance in the San Francisco Bay Area for 22 years, and today we manage over 40 associations. Our specialty is condominium associations and planned unit developments. So if there's any board members out there that would like a professional insurance review, you can always email me at kboland@farmersagent.com, and you can always find me on the internet at kevinbolandinsurance.com. So now it's time to sit back and learn, and I look forward to a great 2022.
Thank you, Kevin, and we very much appreciate his sponsorship of the program today. Our webinar today is Better Meetings and the Open Meeting Act, presented by John Gill and Brian Campisi. Brian Campisi is the president and CEO of the Manor Association, Inc., a leading community association management company with offices in San Mateo and Santa Cruz County. The Manor Association represents common interest developments throughout the Bay Area and Santa Cruz. With over 36 years of experience representing residential and commercial associations, Brian is a recognized leader and subject matter expert in HOA space. He has been a speaker at numerous educational events, and he has partnered with city governments and nonprofits to address municipal efforts, including conservation and sustainability issues or initiatives. John Gill, Esquire, is a founding principal of Hughes Gill Cochran Tinetti PC, a law firm in Walnut Creek. Since 1992, John has represented homeowners associations and property owners in construction defect claims, business litigation, general, transactional, and corporate matters. He has written several articles and has lectured on numerous occasions for trade associations and membership organizations on a variety of topics pertinent to HOA board members, managers, homeowners, and common interest developments. John and Brian are both members of the ECHO Board of Directors. John, please begin. Thank you.
Thank you, Dave. It's a pleasure and a privilege to be here today, speaking with Brian Campisi, a business partner of mine for a couple of decades at this point and a fellow ECHO board member. We're going to talk to you about better meetings and the Open Meeting Act. In discussing this subject, we will talk about some of the specific requirements of the Open Meeting Act, which is the portion of the Davis-Sterling Common Interest Development Act pertaining to board of directors meetings of all types, and also member meetings. We're going to focus on board of directors meetings. We're also going to talk about what we believe to be some best practices for the conduct of board meetings. Brian and I both have decades of experience and have probably attended at least hundreds, if not thousands, of homeowner association board meetings. Thank God we haven't been asked to quantify that yet. And we've got some ideas about best practices to enable boards of directors to accomplish their primary function, which is the conduct of homeowner association business. Most homeowners associations are nonprofit corporations. All homeowners associations that are subject to the Davis-Sterling Act are subject to the principles of corporate governance. The reason I raise that, board of directors meetings are the primary business meetings for homeowners associations. Obviously, there's a community aspect of homeowner association living and board meetings, but the primary purpose of board of directors meetings is to enable the board to conduct the necessary business. The laws coming out of Sacramento primarily have evolved to make clear that most board decisions should be made at board of directors meetings, absent some extenuating circumstances. The laws get stricter and stricter every year. They are not written for the benefit and convenience and comfort of volunteer board members. They are, in fact, they're written for opposite purposes, which is as much transparency as possible to the members while enabling the board to conduct the association's business. So we're going to go through the Open Meeting Act here and also share our thoughts regarding best practices to make your board meetings more efficient, more business-like, without losing a sense of community. So let's go to the next slide, Connor. So when does the board of directors act? In virtually every instance, the board acts in a properly noticed board of directors meeting. For open sessions, which is meetings that the members are entitled to attend, which is most meetings, the board must give 4 days written notice with a posted agenda of the various items of business that will be conducted at that meeting. Then we have executive sessions, and we will discuss what executive sessions are all about. Executive sessions, even though they are kept confidential, the discussions are confidential, members are not entitled to attend, they still require, absent an emergency, 2 days notice with a posted agenda of the various items of business to be conducted. So that's an important concept. Even though members don't have the right to attend, by law, they do have a right to know when the board meets in executive session, absent an emergency, and they do have the right to know the general reason, the general basis of the executive session meeting, the types of items to be discussed for action by the board at executive session. And then what is decided in executive session is generally noted in the minutes of the next open meeting of the board of directors. So Brian, why don't you talk to us a little bit about what actually constitutes a meeting?
Thank you, John. Yeah, so the question is really defined in the Civil Code. What is a meeting? A meeting is a congregation at the same time or place of a sufficient number of directors to establish a quorum, and where that quorum is discussing or taking action or deliberating association business. So that could mean that you have on a 5-member board, you have 3 board members at the pool, sitting next to each other, talking about association business, technically or effectively, that's a board meeting. And this is particularly important in the COVID era, a teleconference or a video conference, where you have a quorum of board members connected through electronic means, again, discussing or deliberating association business. Either of those situations constitutes a meeting, and that meeting, in order for it to be a legitimate meeting, should be properly noticed with an agenda. And then there's the whole issue of email, and we're going to talk about that later in our presentation. But if a board, broad definition, if a board is conducting business via email, a quorum of board members is conducting business, deliberating, discussing association business, then effectively you are having a board meeting. So that's the definition of a meeting.
So in that regard, I like to put it this way. If you have a 5-member board, 2 of you can discuss association business on the side to your heart's content. There's no quorum, and we're going to talk about quorum in a minute. 3 of you, if you run into each other in line at Starbucks or the public pool or the mailboxes, the mail kiosks, or anywhere, it's not that 3 of you can't gather, but as soon as you start talking about association business in any regard, legally, that could be construed as constituting a board meeting. And it's very important that you not have side meetings that aren't transparent with notice and agenda to your members, because there are legal issues with that. It also can foster distrust under the right or the wrong circumstances. I said earlier that the laws aren't written for the convenience of volunteer directors. Email and text message are 2 methods of communication that are becoming, commonplace in our everyday lives. It's really easy to send an email to everybody making a statement. Somebody hits reply all, and all of a sudden you have a problem because you're discussing or deliberating on association business with everybody present by email. That's specifically prohibited. So email needs to be limited to scheduling, administrative, providing information to be discussed later, and everybody avoid reply all. There was a question I'm going to address quickly, and this comes up all the time. And Brian, I'm sure you've had this also. You have a Tuesday evening board of directors meeting. What's 4 days notice? Well, I see people trying to count 4 days as if the day it's posted is 1 day. The day it's posted starts the clock. You then count 4 days further than that. So with my math, which again, grade school goes way back, but with my math, if you have a meeting Tuesday evening at 7 o'clock, you should be posting 4 days in advance on Friday, the notice of the meeting and the agenda. And I say posting, most associations, because they disclose it in their annual policy statement, have a place in the common area where they post the notice and agenda. There are other methods of delivery, but 4 days is count 4 days backward, not counting the day of something happens as 1 day. It's the day. So then you minus 4 to go backwards. Friday would be the posting date for a Tuesday meeting. So if Brian,
go ahead,
did you have
John.
something on that?
No, I was just going to say, one way that we teach it in our office is take the day of the meeting and count back 5, including the day of the meeting.
It accomplishes the same thing.
Right.
So what is a quorum? If we go to the next slide, Connor. Quorum is a legal concept. It's the minimum level of participation needed to take action or conduct business. Now, that's a very generic requirement. Well, for board of directors meetings, quorum should be identified in your bylaws. And I think most bylaws do include a definition of quorum for board of directors meetings. Not all bylaws are written alike. Some bylaws say that a quorum is the majority of the directors. Some bylaws say something to the effect of a majority, I said quorum, a majority of directors versus a majority of authorized directors. Well, those 2 things aren't the same. if your bylaws have 5 seats available on the board of directors, and they say that a quorum is a majority of the directors, you may only have 3 of the seats filled. People are, you have apathy in the community. Well, if a quorum in the bylaws is a majority of the directors, you have 3 directors, a quorum is 2. It's a majority of the 3 directors. If your bylaws say a majority of the authorized directors, well, your bylaws may authorize 5 directors. Even you may only have 2 board members seated. You've got quorum issues. Now, I'm not going to give you a generic answer for what you do with that. You need to speak to the association's legal counsel. It may be that in some cases, your first action should be to make sure you get a 3rd director so you can meet the quorum requirement. But there is no one size fits all for what it is. Check your bylaws. The language is different. There are the bylaws also should define quorum for member meetings. Now, member meetings, we have gatherings every year, but most votes are conducted by email with a secret ballot process now. So there's the quorum for member meetings may also apply to that. You need to speak to the association's legal counsel. In most cases, I believe that's the case. Other member votes, the law defines quorum for member votes for special assessment, member votes to grant exclusive use of common area, and then other votes would be for the governing documents. The big deal here is for a board of directors meeting, usually it's the number of directors seated, but your bylaws may say something different. And the reason quorum matters is having a meeting where quorum isn't present at the beginning of the meeting means you can't start the meeting. So you can't conduct business. If you have questions about that, you should speak to the association's legal counsel.
And John, typically, if you have a quorum to begin the meeting and a director has to leave, that effectively would put you under the quorum count. The meeting still can go on, can continue once the quorum is established.
So once a quorum, that's a very good point. So getting quorum to start your meeting is the most important thing because in most instances, you can proceed with the rest of the meeting solely to discuss the items that were specifically identified on the agenda. Now, 15 years ago or 20 years ago, that last caveat would have meant something because we used to have something on the agenda called new business and you could bring anything up. Now your agenda needs to be specific. And for that reason, it's applicable across the board. As long as you have quorum to begin your meeting, in most instances, you should be able to proceed. If a director leaves, subject to what would have been a majority of the quorum that previously existed approving things. So your quorum requirement doesn't drop when a director leaves, but the amount of votes necessary for something to be approved would remain the same, notwithstanding one of the directors leaving. So you'd still need 2 out of 3 in that example we just talked about. And if only 2 are left, they need to be unanimous.
Right, right.
So open meetings, Brian, what does open mean?
So open meetings, your regular association board meetings are open meetings, meaning that they are open to members, owners of record. The members are entitled to be present at the meeting, and they're entitled to an open forum, which we'll talk about a bit later. The executive meetings, which again, we'll talk about a little bit later, members are not able to attend those meetings. Those are closed and only for the board. Tenants, we often get questions about tenants or renters. Can tenants or renters attend a meeting? The answer is no, unless the board invites them to attend or has a policy that allows them to attend. Board meetings are not open to tenants or other non-members. We often get questions about who should run the meeting. Should the president be in charge of running the meeting? Well, if in Robert's Rules of Order and oftentimes in your bylaws, it'll say that the president is charged with the duty of conducting a meeting. At the same time, your bylaws also say that the directors can delegate those responsibilities. In our experience, the spectrum is everything from the president or a member of the board running the entire meeting and the manager really supporting the board, taking notes, taking the minutes and supporting the board, to the other end of the spectrum where the president calls the meeting to order, introduces everybody, looks at the manager and says, take it from here. So, and then everything in between. So really, it's really the personality and the culture of the community that dictates who's going to run the meeting. We get another question that's sort of related to this around the president, and that is, we sometimes hear from a board that the president shouldn't vote. The only time the president should vote is to break a tie. And just simply that's not the case. The president is a director like all other directors, and the president has a responsibility to vote. That's the board's job, is to make decisions on behalf of the association. And in order to make those decisions, you conduct votes, and directors need to vote. So that's an important distinction. Yes, the president does vote.
You
Go
know,
ahead, John.
Brian, in that regard, that is a really important point, because in 30 years, I've heard many instances where, well, our president doesn't vote, that's our practice. Or the president shouldn't vote, they have to conduct the meeting, they break ties. You need to think of it this way. The members decide who their elected representatives, their elected directors are. And they, whether it's 3, 5, 7, whatever it is, it's typically an odd number to avoid ties. But the members decide who in their community is charged with making the majority of the decisions. The board then decides who fills which offices. The board can elect somebody to an office, president, vice president, secretary, treasurer. They can unelect or remove somebody from the office. But the board members can't remove a director from the board. That's left to the members. So what's another way to ostracize somebody or silence them? That would be a majority of the board saying, we're going to make you president, you don't get to vote. Well, that's not legal. Just as the members decide who the voting body members are, and the board doesn't have the legal authority to change that. Now, as a practical matter, there may be times where it doesn't make a difference in the outcome if the president doesn't vote, but the president was elected as a director to do the corporate business, and saying, I'm not going to vote because there are real legal risks with that to the president, to the other board members that permit it to happen, and to the community at large. So really important to understand that distinction. And legally, the board can't silence the president by virtue of them being the president.
And I would add to that, John, that sort of along the same lines, when boards are voting on a resolution or a motion in a meeting, we frequently run into the case where a board member will abstain from voting. There are legitimate reasons for abstaining. Maybe perhaps there's a conflict of interest. So a board member should not only abstain, but recuse him or herself from that particular vote. Perhaps they weren't at a prior meeting and they don't have the background to vote, and that might be a reason for abstaining, but not always. But more often than not, what we see happen is a board member will abstain because they don't want to vote. They may not be in favor of an issue or the resolution, but they're unwilling to cast a nay vote. And we strongly recommend board members to vote. That's your duty and responsibility, is to vote. If you're not in favor of a resolution because you think that it's not in the best interest of the community, then vote no. If you think it is in the best interest of the community, vote yes. But you should vote when those resolutions are properly put before the board. Imagine yourself, this is more in John's arena, but imagine yourself in some type of litigation and somebody asking you, well, why did you abstain from voting? Don't you have the right or the responsibility to make that decision? So it's important for board members to vote unless there's a legitimate reason not to.
Yeah, being on the board, this isn't a political position. You're corporate directors with a fiduciary duty to conduct the corporate business in what you believe to be the best interests of the association. And in that regard, again, if you didn't attend I think Brian's example was a great one. You didn't attend the last board meeting, and there's a motion and second and vote to approve the minutes of the last meeting as accurate. Well, if you weren't there, it would be reasonable to abstain because you don't have any knowledge that enables you to vote yes or no. But to abstain because something's difficult, or you don't want to anger your neighbors, or you don't think, if you don't think you should be doing something, vote no. A no vote is taking a position. You are elected to conduct the business. That's an important point. The other thing on open meetings, many communities allow people to attend if they live in the community, if their spouse is on title. There's nothing wrong with doing that. But this is a private corporation. Those that are entitled to attend an open meeting are those that are owners or otherwise have a right as the designated representative of an owner. If there's a living trust, for example, that owns the property, the trustees identified in the trust document act as the owner. If a corporation owns a unit, the corporate officers or directors have a right to represent the corporation, things of that nature. But the fact that somebody lives in the community as a tenant, or their parents own the unit, but they live there and they want to show up to the meeting and claim they have a right, well, they don't have a right. You may allow them to attend, but in many cases, you may not allow them to attend. The law allows members to attend open meetings and gives them an opportunity to be heard. So why don't we go to the next slide? Next slide has to do open meetings and an agenda. So before the board can discuss or take action on any item, it first has to appear on a posted agenda. For an open meeting, the agenda needs to be posted with the notice at least 4 days prior to the meeting, unless a longer time is required by the association's governing documents. That's something you need to check. Most bylaws at this point that I encounter don't have a longer period of notice. But if your governing documents do say that, you may want to amend your governing documents to give yourselves more flexibility to post an agenda 4 days in advance. I've seen a couple of questions in the Q&A on the Q&A line about how do we count 4 days. Again, for a Monday meeting, 4 days prior would be Thursday, counting backwards. You start with Monday, you go back 4 days, it would be Thursday. There's a question about, do you have to have an agenda for a committee meeting? We're not really here to talk about committees today, but most committees don't have decision-making authority. They meet, they discuss, they do research, and they report back to the board for the board to be able to consider information to conduct business. None of these rules apply to committees. You don't have to have open committee meetings. You don't need notice. You don't need an agenda. You don't really need committee minutes unless you're in a situation where the committee has decision-making authority under the governing documents or is given the decision-making authority by the board. In those instances, you really need to consult with the association's legal counsel about how to handle that. But back to the agenda for an open meeting of the board. Again, 20 years ago, there was an agenda item for new business. And in new business, you could basically bring up anything to be discussed because the requirement that something be on the agenda specifically to be deliberated upon wasn't in effect in the Davis-Sterling Act. Well, now there's no such thing as new business to bring up anything you want. And in this regard, the law does treat homeowners associations differently than other nonprofit or for-profit corporations. The rules are different for you because people have a vested stake in the community and ownership interest in a separate interest. There was a question again about going back to quorum that I saw. Is there a difference between getting together and making decisions versus getting together and talking about things to be decided later? The law, it doesn't just say that it's a quorum of directors getting together to conduct business. It talks about discussing and deliberating. So and there was another question. What if you have a landscape walk with a quorum of the board present? Shouldn't that be posted with a notice and agenda? Anytime you have a quorum of directors discussing association business, the law considers that a meeting. So if you have 3 directors out of 5 going on a landscape walk, it would be very wise to reduce the number of directors participating to 2, and you don't have a problem. If you have a 3-member board, you should only have 1 going on the landscape walk. Otherwise, you are at risk of running afoul of this area of law. How do we set agendas? There is nothing in the law that says, here's how you set your agenda. So this really is a best practice. And I know from 30 years in the business, this is what I recommend the board adopt as a policy, but this isn't set in stone. This is what I think makes sense. First, if you have a professional community manager, the manager implicitly understands what needs to be done at the next board meeting based on the work the manager is doing between board meetings and reporting back to the board. So if the manager says we need to have these items on the agenda, it would be a rare occasion in my estimation where the board should overrule that. Second, the president is elected to basically be in charge of running board meetings, the titular head of the board. So in my estimation, the president typically is in touch with the community manager between meetings, typically as a designated point of contact. So I would give the president the latitude to make sure certain things are on the agenda, working with the manager. Again, best practice, not legal requirement. Beyond that, if you have a 5-member board and every director gets to put anything they want on the agenda, you run the risk of meetings that really are a collection of 5 people with individual agendas that want to bring things up month after month after month. Now, that's not always the case, and it's not that each person isn't important with their perspective, but as a practical matter, in order to conduct business at a meeting, you have to have an item of business that is subject to a motion and a second. So I think the best practice for the remaining directors is if any 2 directors decide they want something to be on the agenda, it's enough for a motion and a second leading to a vote. I think that's reasonable. So if I were writing a policy in my world, I would say the board should adopt a policy or a practice where the president, the manager, if you're managed, or any 2 directors can get something put on the agenda. But it's something that each board needs to discuss and decide how you're going to do it so that everybody's treated fairly. Brian, how have you dealt with that issue?
Again, best practice. What we encourage our clients to do is we will prepare the initial draft budget. We will send that to the board president. And then the board president will distribute that to his or her colleagues on the board. They will decide what items will be on the agenda, and then we get the final agenda back from the president, and that's what we post. So we really encourage the board to work through the president to establish what will be on the final agenda. But as you mentioned earlier, if we have 5 board members all kind of feeding into the process and providing us different topics for an agenda, the agenda becomes, almost unusable because there's just too many topics or too much to cover in a single meeting. May not have the supporting data to have a realistic discussion about those topics. Where it gets difficult is when there is conflict on the board and board members are arguing with each other about what should or should not be on the agenda. That's where it gets a little challenging, and where if that's the case, the board should have an agenda policy so they can give someone the authority to make the final decision on what goes on the agenda.
So the next slide is going to deal with what if something's not on the agenda, but there's a question here: how specific does the agenda have to be? The agenda doesn't have to be as specific as you might believe. There's a question here: can the agenda say landscape proposals? Sure, yes. The point is to tell the members, we're going to discuss these general areas of business you may want to attend. You give them enough information to know to be able to make a determination if it's worth their while to do what's necessary to attend. The question says, can an agenda say landscape proposals, or do the proposals have to be listed? There's nothing in the law that says you must itemize each one. Your manager may be continuing to gather information up until the meeting, but if you give 4 days notice and an agenda that says we're going to consider landscape proposals, the idea here isn't to shut the board out from conducting necessary business. It's to advise the members of what items of business are going to be discussed. And I think you can be more general. If you have specific questions in that regard, you should speak to legal counsel to make sure you're protected. But just with that example, I think the more general description is entirely appropriate to advise the membership of what's going to happen at the next meeting. So there's also a question here about what about acting on items not on the agenda? And happily, I believe that's our next slide that Brian's going to cover. So if we go to the next slide, Connor.
So yeah, this comes up all the time. Boards often feel handcuffed by the rules surrounding the Open Meeting Act, in which you can and cannot talk about. And the intent of the legislature, as John mentioned earlier, was really to prevent the board, one way of saying it, preventing the board of taking action on items that the membership had no notice. So the board is required to restrict their discussion to what's on the agenda. So what if something isn't on the agenda? What can the board do? The board or the manager can briefly respond to questions from, say, during open forum. A member may have a question about something that isn't on the agenda. They can briefly respond. They could ask questions from that member if the board needs clarification. They could ask clarifying questions. They can make brief announcements, or they could report on activities. For example, if the board at a previous meeting had decided to install a new pool heater, it wasn't on the current agenda, but a question came up about the status of that project, the board can certainly report on the status of the project by simply saying, we're waiting on the pool vendor. The pool vendors ordered the spa heater and they're scheduled to put it in a week or so. They're not making a decision. They're just reporting on the status of an activity. So they can certainly do that. The board can refer, refer tasks to the manager. For example, if a topic came up during open discussion and it warranted going on an agenda, the board can certainly instruct the manager to put it on the next month's agenda, or to investigate a problem in the community if somebody reported something in the community that needed some investigation. If there is an emergency topic or issue, and we're going to talk about emergencies later, I think this gets overused a little bit, but if there's truly an emergency, then the board could go ahead and discuss and take some action. And John will talk in a little bit about what constitutes an emergency. Unfortunately, and this happens quite a bit, topics do come up in meetings that are not on the agenda. The manager will advise the board, at least that's our practice. Will advise the board that this topic is not on the agenda and we cannot deliberate or make decisions on this topic tonight. And it does happen.
So really quickly, we are going to have a slide in a bit about emergency meetings, but for purposes of your understanding here, if the agenda is posted and something comes up between the agenda and the meeting that wasn't known, can't wait, requires action, in many circumstances, the board can act. And we'll explain that in a little greater detail in a few minutes. With regard to the final bullet point here, what the Civil Code says is, and this is, I think this is 4630, I'm sorry, it's 4930 D3. The item appeared on an agenda that was distributed pursuant to 4920 for a prior meeting of the board that occurred not more than 30 calendar days before the date the action is taken on that item. And at the prior meeting, action was continued to the current meeting. So it's not just was on a prior agenda, it's supposed to be within the last 30 days. At that point, you've got a little bit of latitude if that item was tabled to the next meeting, and the next meeting is 30 days, is within 30 days. So
Yes.
something to keep in mind there. Otherwise, the whole point of the agenda is to advise people of the items of business or the areas of business to be deliberated upon by the board at the meeting, to encourage members to attend, or at least to be able to make a value judgment. So then we get to what happens in open meetings with member participation, the homeowner forum. This is the next slide. The homeowner forum, the law requires that members be allowed a reasonable opportunity to address the board at any open session board meeting. You notice the language here is to address the board. What I see happen quite frequently, and I don't mean this to be critical, it's the one time the members get to be in front of the board and be heard. What I see frequently is a demand to have questions answered, and a demand that action be taken and be taken immediately. Well, member forum is their right to be heard. Legally, it's not their right to get specific answers in the moment. Now, it may be reasonable under the circumstances if somebody shows up and asks, they've got a couple minutes for their time, and they ask, what did we ever do about X? Or did anybody ever look into X? And a board member or the manager says, well, here's what we did. We dealt with this last meeting, or it was irrelevant because, and you give a reasonable explanation and everybody's happy. But I've also seen situations where somebody says, I have 5 questions and I demand answers now. You work for me. I pay your salary as volunteers. Whatever it is, being a little absurd here, but I demand answers and I demand you take action tonight. Well, it may be awkward, but the directors aren't required to provide instantaneous answers, instantaneous value judgments, and to take action on something solely because somebody shows up and demands it. And in many cases, it may not be possible for the reasons that Brian was just discussing on the last slide, which is, well, it's not an item on the agenda, but we appreciate your input and we'll take it under advisement, and we'll look into that and we'll consider whether we want to put that on a future agenda. If somebody gets angry at you for that answer, the response is, well, legally, we're not allowed to. This isn't an emergency, but again, we appreciate your input and we're glad you were here to make your views heard. The whole point is that members have a reasonable opportunity to address the board and be heard. The law also says that the board shall, and the operative word is shall, establish time limits for member participation. We recommend 3 to 5 minutes as being pretty typical, but it's not just each member. Your volunteer directors showing up once a month, every other month, quarterly, whatever it is. And the fact that, everybody wants a piece of time to address you, that's great. It doesn't mean you have to have a 2-hour member forum. So establishing 3 to 5 minutes per comment is common. You also can establish time limits on the entirety of the member forum. 15 to 30 minutes isn't unusual or unreasonable in my estimation. But you want to keep it all in context. Sometimes you show up to a board meeting and based on what's happening and what's on the agenda and what the chatter is in the community, you're going to have 30 people there that want to hear what's happening and talk, whereas typically you may get 3 to 5. As an example, if there's a hot button issue or a couple of hot button issues, I think you want to be flexible to say, we're going to allow 30 to 45 minutes for a member forum because the community needs this and it will help diffuse this or put people at ease, or we want people to be heard and have a full airing. So let's say you say 45 minutes because there are a bunch of people there. A reasonable way to implement that would be to say, we typically have a 15 to 20 minute member forum, but it looks like a lot of people want to be heard. Could we have a show of hands of how many people wish to address the board? 15 hands go up, hypothetically. At that point, it would be reasonable to say, we're going to allow up to 3 minutes per person that has asked to be heard for a total of 45 minutes tops. You could say, because we have so many people, we're going to limit comments to 2 minutes. It simply has to be reasonable with everybody treated fairly. Then we see situations where people appoint a spokesperson and they want to delegate their time to that person. This is not a congressional hearing or a congressional action or legislative body. It's a corporate board of directors meeting. I would encourage people in that instance to put their views in writing for the board to consider prior to the next meeting if they don't want to speak, but want somebody to speak for them. But there is nothing that says you need to allow everyone to delegate their time to one person to take up 30 to 45 minutes. In fact, from my perspective, that's counterproductive. And in most instances, barring something unique to this situation where that might be helpful, it is entirely reasonable to say, no, we're not delegating time. You don't have 20 seconds left to give to this person. You have 3 minutes if you want it. And if you're not going to use it, we're moving on to the next person. You know, this is, I think that's a reasonable way to allow everybody to be heard. And if they choose not to be heard, that's fine. Then there's somebody keeping the clock. You don't want to be oppressive about it. It's like somebody may need 3 minutes and 20 seconds and there's nobody else behind them. What difference does it make? But if you have 25 people wanting to be heard with a 2-minute time limit, somebody needs to be keeping the clock so that you can get through this and move on to the meeting. The last point, the board isn't obligated to respond or address to everything said or asked by a homeowner. We already talked about that. You really need to look at the totality of this, what's reasonable under the circumstances, and allow it to happen for the betterment of the community. But as directors, you're not obligated to sit there for an hour and a half listening to somebody's tirade because they're not going to cede the floor. And if somebody won't stop talking when their time is up, you can adjourn the meeting for 5 or 10 minutes and come back and pick up wherever you are. The board controls the meeting. You want to do it reasonably. And those are the things that the law discusses in terms of how to do that. The last part of this, if you allow spouses of an owner or renters, tenants to show up to your meeting, they don't have a legal right to be heard. They don't have a legal right to be there. In fact, it's really at the board's discretion. And while I don't mean to be anti-tenant, for example, tenants often have a different view of what the homeowners association is about than someone that actually owns a separate interest. This is not apartment living. This is not Airbnb living. It's a homeowners association. So if you get to the point where you begin allowing non-owners to address the board, you run the risk of getting into areas that really aren't areas appropriate for a board of directors meeting with non-owners speaking. And in terms of who the owners are, we talked about trustees of a trust, corporate officers or directors. The same types of things apply. I'm going to give a plug to another ECHO program. The same types of things apply to who is now eligible to nominate themselves as a candidate for the board. The law has changed recently that it must be an owner, a member of the association. And so my plug is, I believe next week, ECHO has another program regarding the elections law, a presentation from a couple of attorneys with Swedless and Gottlieb, including Sandra Gottlieb, who's very knowledgeable in this area. We would encourage you to attend, but the same principles of who's eligible to run for the board would apply to who has a right to attend a board of directors meeting.
You know, John,
So-
quick story on the open forum is, most open forums are very civil and boards manage them very well. Occasionally you get there may be a very contentious issue in the community and the open forums become very challenging. In that case, a best practice there is to establish an open forum policy. We had a situation once where the open forum would literally paralyze the board from doing any of its business. They finally adopted an open forum policy, and they had to adjourn the meeting, and they had to do it 3 or 4 times, adjourn the meeting completely, and then reschedule a new meeting in order to conduct their business. But finally, the members, they got the idea that we're not going to be able to sit here and yell at the board for an hour. And it worked so well that actually the members started policing themselves with respect to the open forum. So if somebody got out of hand, it was another member that would say, hey, look, you have to abide by this policy or the board is going to adjourn and walk away. So it worked very effectively. It doesn't happen a lot, but it does happen.
You know, I agree with that. And in terms of policy, there's something else about the conduct of meetings. And we want to think of this in the context of you have a group of volunteer directors that get paid nothing to show up and make the hard decisions. And we talked about it in terms of should you abstain? Well, rarely. We also need to foster an environment where we're not discouraging volunteers from being willing to show up and conduct business, because a group of 10 people shows up every meeting and demands the floor for an hour. You not only do you not have to do that, but there's another part. Once the member forum is concluded and the board begins to discuss association business, member participation is over, except to the extent that the board asks someone to comment on something, state what it was they observed that the board needs to consider, or what have you. I've been to many, many board meetings where every item on the agenda, members raise their hands and want to weigh in. As board members, you can do that if you want. It's a recipe for very long board meetings. One of the reasons to put these things on the agenda is to encourage people to show up and speak during the member forum. But once the board is conducting its business, you legally are not required to, and I would say you should discourage members from intervening and adopt a policy that once we're moving on to the business part of the meeting, the only people authorized to speak are those recognized by the chair of the meeting. Now, the chair of the meeting is it's either the president or maybe a delegate to the manager or the vice president if the president's gone. All of the directors have to have an opportunity to weigh in and be treated fairly. Nobody in the audience has a legal right to interfere with the board's conduct of business. So there may be times that there's something you're dealing with and somebody in the audience has some unique knowledge of something that happened or how something works. Well, the board can ask somebody in the audience to provide information that might be useful to the board and maybe educate others in the community to why this is even being discussed, if you think that's helpful. But the idea that everybody gets to chime in as the meeting progresses through each item of business, I think that has a very negative impact on board meetings and the board's ability and willingness to show up, do business, and keep the meetings efficient. If that has been your practice, and you want to discontinue it, there's an educational process that has to be done. And as Brian said, adopting a policy about the member forum, it would also be a policy and practice of how the meeting is to be conducted. And I think you want to advise people of that at the beginning of the member forum. Here's how we're now going to do this going forward. So please be advised, once this is over, we're moving on and it's board members only. I think that's a really important point to encourage people to keep serving, frankly. So we've addressed this quite a bit. It is a big deal for efficient meetings and to sort of keep the heat down in terms of the vibe of the meeting. Then we have executive session meetings. Brian, why don't you discuss that?
Sure. Executive session meetings, as I mentioned earlier, are closed to the members. They're attended only by the board and whoever the board may invite to the meeting. Executive session meetings, even though they are private meetings for the board, they still need to be noticed to the members. The notice requirement is a little different. It's 2 days notice instead of 4 days notice. Executive session meetings are limited in terms of what you can discuss. They're on the slide there. It's the formation of contracts, which I'll talk about in a second, member discipline, personnel matters, litigation, and delinquent assessments. Those are the only 5 topics that you can discuss in executive session. So we often get questions about, well, what does formation of contracts mean? And really, we look at this very broadly. So a discussion around contracts could be the formation of the contract. It could be the termination of a contract, the editing or review of a contract. So we apply a broad definition to the contract discussion. Member discipline, this is an enforcement topic where a member is perhaps violating the rules and you call them in for a hearing. So that would be member discipline. For associations that have personnel, you can have an executive session for personnel reasons. And litigation. So litigation is another one of those topics that we apply sort of a broad definition to it. It doesn't necessarily mean that the association is in litigation. It may be a legal matter that is either pending or perhaps the association is concerned about, a discussion you might be having with your attorney. It doesn't confine you to topics that are only in litigation. And John perhaps can expand on that a little bit. And then delinquent assessment. So you have an owner that you're working through a payment plan, or you're making a decision to foreclose. That's another valid topic for executive session. In executive session, it's confidential. So the board has an obligation to keep that discussion confidential. The minutes of the executive session are also confidential and private. The only requirement is that the open meeting minutes record the fact that there was an executive session meeting. With respect to the agenda for executive sessions, again, we advocate keeping the agenda general. And what we do in our practice is really follow the 5 bullet points. So if it's a discussion around formation of contracts, we'll put on the agenda contracts. Or if there's a legal matter that the board is going to discuss, we'll put legal. But we keep it general. We're definitely not going to put specific information about member discipline, who or what we're discussing at the meeting. John, you want to talk a little bit about litigation?
Well, sure. So matters pertaining to litigation can be taken as very specific. I think there is a legitimate reason to treat that more general. Any potential dispute, legal dispute, or something that involves the association's attorney giving legal advice to avoid a legal dispute is something that could pertain to potential litigation. The reason I explain it that way, the board of directors is the governing body of the corporation, the homeowners association. The board of directors is the body that works with legal counsel to make sure that things are functioning properly in a legal way, or that the association avoids legal liability, legal losses, things of that nature. The relationship, the attorney-client privilege relationship between the association and legal counsel is primarily between legal counsel and the board of directors. And if you have professional management, your manager as the managing agent would also be subject to attorney-client privilege in communications with legal counsel. There is a legitimate reason for attorney-client privilege communications to be conducted in private and perhaps outside the earshot of the members, because the members don't have a legal obligation to keep things confidential. The board members do if there are matters that are supposed to be kept confidential. So in my estimation, anything where legal counsel needs to communicate with the board in a privileged and confidential manner, when I see litigation, I would bootstrap it into anything that, if it goes the wrong way, could result in a litigation scenario. And the avoidance of litigation is just as important and just as confidential as what do we do if we find ourselves in it. The formation of contracts is probably the squishiest part of the categories that you can go into executive session for. The fact that you can handle contract formation in executive session doesn't mean you have to. You can deliberate on contracts and make choices on selecting one contract over the others or the necessary terms. You can do all that in open session. There's nothing wrong with that, but you have the flexibility to do it in private to discuss things that could have a negative impact if they're discussed openly in the community. So contract formation is the one that we talk most often to boards about. Can we do this in executive session? If there's any potential controversy, it might be a good idea because the controversy can override what board members believe to be in the best interest of the association. Member discipline by definition ought to be kept private because there are privacy issues. Personnel matters, same thing. Delinquent assessments, same thing. These are all things where privacy interests need to be paramount. With that said, doing things in executive session to avoid having to deal with member opinions about them isn't why you go into executive session. It's to protect things that may be proprietary, privileged, confidential, and those matters need to be kept that way for a specific reason. And formation of contracts, there may be proprietary information unique to some of your vendors that goes into that as well that would also gravitate toward handling that in executive session.
Yeah, we often get the question during budget season, the board wants to meet privately to review the budget before we take any formal action on it in an open meeting. And, that's not a legitimate executive session topic.
So remote meetings, we have a slide on remote meetings, and remote meetings have become the norm. Everybody's become familiar with Zoom primarily. But the law is very clear about what happens with a remote meeting, a teleconference, a video conference, other than in where there's a declared emergency that makes meeting in person impractical or impossible or unsafe. And there are things that have to be done there. A remote meeting should occur with a person directed by the board to be present in a physical location if members want to show up in person to the physical location to observe the meeting and be heard. So in the absence of a declared state of emergency where it's impossible, can't be done, or it would be unsafe, the current COVID environment, we don't have a state of emergency saying we can't gather. Now, there may be limitations on gatherings. I think most people at this point are reluctant to gather in large numbers, and maybe directors, management want to do it all remotely. That's fine. But legally, in the absence of a state of emergency, you really need to have a person designated by the board to be present in a physical location if anybody wants to show up in person and attend. If it's conducted via a video conference, and there's a state of emergency, there are certain things that have to be done. What is a state of emergency where this might apply? If your community is in fire country, and there has been, as we've seen all too often the last few years, a fire that devastates neighborhoods or cities or what have you, it may be impossible to do anything other than meet remotely. The law has specific things you have to do, including individual notice of the meeting to everybody to the extent possible, clear instructions on how people can log in or dial into the meeting. You even have to have a person designated to provide technical assistance before and during the meeting if you are conducting an entirely remote meeting due to a state of emergency. But again, the current scenario, everybody's gotten accustomed to Zoom. I don't think that's going to change. You still have to allow an in-person location if we don't have such a state of emergency. And there's no reason you can't have hybrid meetings. And it may be that nobody shows up in person in somebody's living room, conference room, whatever have you. Everybody can still show up by Zoom. And I think we're getting better attendance doing that. Executive session meetings, you simply need a quorum of the board to participate. You don't have to have the physical location for that because it's not about member attendance and participation. The other thing we have, next slide, circling back to emergency meetings, just to flesh this out. What is an emergency? It's where there are circumstances that could not have been reasonably foreseen, and which require immediate attention and possible action by the board. and which of necessity make it impracticable to provide notices required by law. So a perfect example, you have a community manager or a board member that is in self-managed communities delegated to handle the insurance. And you've just been notified that your policy renewal that you had believed all along was going to bind on such and such a date. You get a call from your broker and they say, you've got 36 hours to take, or you've got 3 days to take the following action, or this policy is going to be canceled. You're not going to renew. The board needs to make this decision. Well, you don't have enough time to give 4 days notice, or it occurred in the interim between when the notice and agenda went up and your meeting. It can't wait. It requires immediate action. That would be an emergency situation. At that point, the notice and agenda rules don't apply. The board can meet because it's legally deemed an emergency situation. You see the thing at the bottom. Most situations are not genuine emergencies. And even if you didn't know at the time the agenda was posted, if it's something that's not urgent, if it's something that can wait a few weeks for another meeting to be called, it may not be a genuine emergency. And in many cases, probably isn't. If you have questions about that, it is important to speak to your legal counsel to be sure you're not acting too hasty without notice and agenda, because the absence of notice and agenda could be a basis for someone to challenge the action. That doesn't mean that if somebody challenges the action, they automatically are going to get it overturned, but you want to have confidence in the community and the way the board is behaving, and you want to be above reproach as much as possible. So an emergency is an unusual circumstance, not a typical one. And I think if you think of it in that fashion, you'll be okay. We're down to the final few slides, and we probably need to cycle through this. So Brian, why don't you take us through meeting minutes?
Quickly, yes, we are running long on time here. So meeting minutes. Meeting minutes are an official record, association's record. They are meant to record the decisions that the board makes at a board meeting. Shut that off. They should not include all the detail regarding discussions and deliberations. They're meant the meeting minutes are meant for the internal use of the corporation. The way that we coach our managers is simply keep them brief, keep them simple, record the actions taken by the board. They're not, he said, Jimmy said this, Sally said that, John said this. They're not meant to do that. And when we're sort of teaching this to our managers, what we'll say to them is, imagine in litigation, having to hand over 6 pages worth of minutes with everybody who said anything in them, how much fodder you're giving the attorneys, no offense, John, but how much fodder you're giving the attorneys when you keep your minutes that way. So really think about it in terms of recording the actions taken by the board. It's the board's decisions.
Yeah, so I like to say minutes aren't a transcript of proceedings. They're a record of the actions taken at a meeting by the board, so that 5 years from now, if somebody needs to know when was this done, you can go back to the meeting minutes and find it out. So there was a question earlier, if there's a motion made and it's later withdrawn, should it be included in the minutes? In my estimation, just sort of off the top of my head, yeah, if somebody made a motion and then withdrew it, you don't need a full explanation of all the discussion that resulted in the moving board member withdrawing it, but a motion was made and maybe seconded and then subsequently withdrawn, and you can explain it that way. The other big deal is member forum. I've been to member forums where people demand that their concerns be included in the minutes. That's not what the minutes are for. Saying there was a member forum is appropriate. Identifying what everybody said, just like you don't need to identify what every board member says in response to each motion. I think it's a bad practice. I think it's a liability trap for associations, and I would discourage anything other than a member forum was conducted and a brief description in that regard. Risks of email. We have 2 slides on risks of email, and I'm going to be brief. We talked earlier, emails can inadvertently constitute a board meeting if a majority of directors are on the email string and you're discussing association business. A series of emails can be a board meeting. You need to avoid this. And the key to all of it, if a director sends an email with information to be considered by all the directors at the next meeting and attaches, this is for discussion at the next meeting, that's all it is. A reply all with a discussion is the most dangerous thing going. So don't do it. It can't, and you can, we talked earlier, you can meet via email in an emergency situation. We just described by that what that is. And if all directors consent in writing to the action, unanimous written consent. This is really the only place where it really applies. Boards in an emergency can make a decision entirely by email if it's unanimous. If you're not unanimous, you need to call a board meeting, and you can call an emergency board meeting with virtually no notice if you can get a quorum director, if all the board members themselves are notified. To the next slide, risks of email. The E in email sometimes might be evidence mail. I've been in trials on governance issues and enforcement actions between association and member, where board member emails discussing the person that filed the lawsuit or the person that is the subject of the dispute are being referenced in very unflattering, negative, sarcastic, snarky ways. It doesn't do anybody any good. Those things make their way to a jury. Those things make their way to a judge. You may not get a fair shake. I've got a couple stories that we probably don't have enough time to get into, but everything you write in an email can be discovered in litigation if it's not between attorney and client, client and attorney. So the flippant emails that you wouldn't want to see published on the front page of the newspaper, you need to not do it. Another point, using your employer's email, using your personal email to discuss association business, emails can be subpoenaed. And the last thing most people wouldn't want that they may not think about is what happens if we're in a lawsuit and my emails get subpoenaed and I'm using my employer's email. Well, now your employer gets dragged into an HOA dispute that you never saw coming. So a best practice would be for all directors to set up a personal email exclusively for board business, receiving board packets, any communication about association business that has to be done by email. Have a separate account so that if there's a subpoena, you can legitimately, legally say, well, the only emails that would apply are from this account, and your boss doesn't have to be notified, which could really result in bad or uncomfortable things at a minimum. So finally, we're going to conclude with conduct and behavior at meetings. And Brian, that's you.
Well, thank you, John. I often say that the conduct of a board has a ripple effect through the community. So when we talk about good conduct for a board, we talk about respecting your counterparts on the board. Whether you agree or disagree with an issue, it's important to be respectful about your disagreement. The idea is for issues to be discussed and voted on. The board's job is to vote. And sometimes you're on the winning end of that vote, and sometimes you're on the losing end of that vote. Regardless of which side you're on, once that decision has been made, the expectation is to go shoulder to shoulder with your colleagues on the board in support of that decision. And when boards behave that way, as I say, it generally reflects how the community responds and reacts to the board. On the other hand, the contrary is true. When there is somebody on the losing end of a vote walks away from the meeting and has nothing but terrible things to say about their colleagues on the board to their neighbors, that also trickles through the community, and it tends to be reflected in how the community responds and reacts to each other and to the board. So the expectation is really to be respectful, to understand what your job is, and that's to make decisions and to vote. And once the vote is made, to be supportive of each other moving forward. Speak with one vote and promote respect for the decision-making process. The best run communities really embody that practice.
I guess my last comment on that last point that I agree with Brian is very important. Speaking with one voice, corporate directors should deliberate, debate, disagree, have hearty disagreement and debate. That's healthy. Once a decision is made, the concept of speaking with one voice doesn't have to be, I'm thrilled with this decision. Speaking with one voice is encouraging the members to respect the process that resulted in the decision, even if we're not happy with the decision, because respect for the process and respect for the board conducting the association business may be all people are left with if something happens they don't like. But if there's disrespect for the process, these aren't political positions. If there's disrespect for the process, all you're ever going to have is strife. Nobody wants to live in a community that gets nothing with strife. So as directors, if you can all agree to support each other and support the process, even where you disagree, because you respect each other, you will engender respect in the community. And that's a really big deal when you most need it.
Yep.
Okay. Well, thank you both very much for your time. I think we're on to the question and answer period session. So let's go ahead and move into that. This question and answer portion of the webinar is sponsored by CID Consortium LLC and Hughes Gill Cochran Tinetti. Thank you for your support and continued support of ECHO. A short reminder to vote for your favorite questions by using the thumbs up icon in the Q&A feature. If you could please go to the thumbs up or to your Q&A feature and vote, that would be great. This will help us to prioritize questions. So thank you for doing that. We'll give you 30 seconds or so to pick your favorite questions, review them, do that, and we'll go right to the top and pick the ones that respond and have the most votes. So let's take a few seconds here and do that. Thank you again, John, and thank you, Brian, for your help with this. It's very educational, very interesting, and I learn something new every time. So thank you for that.
You're welcome. So do I, by the way.
Me as well. Yes, absolutely.
Yeah.
I think there's some really good questions too by the participants here. Certainly we do get calls on these on a regular basis. So thank you so much. All right, so let's go to the top of the list and see what we have here. I believe it's 8 responses from James Taylor, 8 votes. I requested information from management regarding the number of rental units in the complex. Reply was that the information was only provided to owners and refinance owners in escrow. My understanding is that HOA provided info in escrow is available to all members unless it involves delinquencies or rules infractions. Which of you would like to handle that one?
I can react to it in this way. If you have a rental policy and a process by which members have to apply for the right to rent, which often is the case if you have a rental cap, resulting in the importance of the number of renters in a refinance, for example, members have a right to know where they would be on a wait list if there is, for example. I don't think the number of renters is a confidential matter.
I agree.
Okay, so let's see, I'm trying to get, there was 10, a couple other questions.
We should say in answering any of these questions, there's no way we know all of the details that might affect an answer. So when Dave gave a disclaimer of, this isn't legal advice to rely on, again, we're answering in general terms based on what we think we know that goes into the question. But that would be my answer.
Okay, so here 11 people voted for this one. If the board, this is from Stephanie, if the board schedules a walkthrough with a vendor such as a landscaper and there is a quorum of board members present, does this need to be posted?
I think you run the risk of having a board meeting that you didn't post notice in an agenda. I think we actually did touch on that during the presentation. So if you have a 5-member board, the way you avoid a risk is to not have a quorum on the landscape walk. Somebody would need to volunteer to not be part of it. Because by definition, if your landscape walk is talking to a vendor about how they're doing, how they're fulfilling their contractual obligations, I think you have a problem if somebody chooses to raise a fuss about it, and it should be avoided. You should avoid having a quorum.
Okay, and here's a question from Anonymous. Anonymous would like to know, when should board of director packages be given to the directors before meetings? How, I guess that means how many days, how many hours, when should they be given to them before the meeting? Could it be given as they become available?
Typically we want to give the board their packet with enough time for them to review the packet in advance of the meeting. One of the things that managers often complain about is arriving at a meeting and a board member, ripping open the envelope when the meeting's being called to order. So our goal, the goal should be to deliver the packet several days prior to the meeting, so that the board member has an opportunity to review the material and prepare in advance of the meeting.
That's great.
Yeah,
Okay.
I think it's a best practice, not a legal issue, for what it's worth.
Right.
But that would be best practice.
Okay. And question I got was about what you share to the documents that can be requested and received from a member of the community, HOA homeowner. They requested a copy of contracts. If the contracts are duly executed, are those contracts available to all homeowners?
Yes, so there's a portion of Davis Sterling that talks about member access to association records. And we could do a presentation that would dive deeply into this, but executed contracts that are not otherwise privileged are the type of document that needs to be made available to the members upon request. You're not required to give them out as a matter of course, but if a member requests it, and I would say requests it in writing, so you have a record of it, in most cases, I think the member's entitled to that.
Okay, and that includes the management contract?
Yes.
Yes.
Mhm.
Yes.
When should minutes be drafted and then released to the community, made available to the community?
So the draft meeting minutes have to be available, 30 days, John, within 30 days of the meeting. So you have to produce a draft within 30 days of the meeting, and that draft is available to the membership.
Mhm. What's your best practice with that, Brian? How quickly do you usually want to do it?
We like to have the minutes, the draft meeting minutes completed within 7 days following the meeting, and those will go to the board. We typically don't post the draft meeting minutes, so unless somebody asks for them, we'll wait until the minutes are approved and signed, and then those are the minutes that are posted typically on the web portal.
Okay, and then those.
And we're talking about open meeting minutes,
Right.
by the way.
Right.
Executive session, confidential and private matters. The only mention of what happens in executive session is in the minutes of the next open meeting. So people may not get wind of what actually happened in some cases for a couple or 3 months, depending on when the next open meeting is, and then minutes are prepared. But executive session minutes should not be given to everyone. They're supposed to be confidential.
And John, I saw a question in here about what should be reflected in the open meeting minutes about the executive session. So how detailed or general should that be?
It could be the board met in executive session with legal counsel and authorized legal counsel to file a lawsuit or a binding arbitration, submitted binding arbitration demand for such and such. It could be the board met in executive session and accepted, authorized and approved a contract with ABC Landscaping.
Okay.
Okay. Here's 13 upvotes on this one. Our board discusses proposals from a single vendor in executive sessions such that owners never know what the proposal is about. should they first discuss and vote on the item in open forum before voting on proposals in executive session?
Well, all I can say is that there may be variables that are coming into play here that we don't know, but matters related to the formation of contracts are appropriate for executive session. And if they're appropriate for executive session, there isn't a prerequisite that they first be discussed in open.
Yeah. And I think you probably don't want to catch your homeowners off guard. So it should be known that you're going to look at landscaping or whatever. So that.
Well, and the executive session minutes can reflect that. Again, executive session is where you have the flexibility or reason to do something to be kept confidential. There's nothing that says you can't discuss vendor contracts in an open session and approve them in an open session. I think that is probably the squishiest topic in terms of transparency versus confidential.
Okay, here's another one that received, let me get back up to the top here. 11 votes or 13 votes. What is the best practice for boards to evaluate its management company's performance and consider potential replacements? Can such meetings be conducted in executive session without management present? How noted is any agenda and or minutes? And I'm going to throw a plug in too for this, because we do have an entire program on assessing your management firms. It's coming up by John Clinty, and it's going to be in a couple, I think it's going to be in March. So it's coming up very, very closely. But to answer the question at hand here, how do you do that? Do you have to have, someone, the management firm there in the meeting?
You don't have to have the management firm in the meeting. We get asked that question. But in terms of how do you assess the management company's performance, I think the first thing to do is you have to make sure that you understand the contract. So, what are the service level agreements in the contract? And then I think it's best practice for the management company and the board to sit down at least once a year and review performance and review the contract and to make sure that everybody's living up to their obligations. And if there are corrective actions to be taken, that those are documented, and that way the next time you sit down you can talk about it again and see how you're doing. But unless you understand the contract, and two, you're talking to your vendor, whether it's your manager, your pool provider, or anybody else, you're talking about performance, you're probably not managing it very well.
Got it. Yeah, that event is March 10th. And we are going to go through an assessment template. We are designing an assessment template. The board members club asked us to do that, so we are working on it. John, you were going to say something?
One of the difficulties I see in this type of a situation when I'm asked by board members, how do we do this, is implicit or sometimes explicit. We don't want our management company to know that we're considering going elsewhere, or that we may be taking this action. So it comes down to, how do we do an executive session without our manager knowing? Two things on that. One, my immediate response in virtually every situation like that, unless I understand something unique that doesn't matter here, is to ask, have you sat down and done exactly what Brian just said? Have you talked to your manager or your manager's boss, the head of the company, whomever, about your concerns and ways to improve the relationship? It's amazing how often that doesn't happen. And I think it's a real lost opportunity. The relationship between board and manager, board and managing agent, is a really unique and difficult one. And sometimes with new directors coming on, there isn't an appreciation for that, or there isn't history. These things need to be discussed openly. And in the absence of something pretty dramatic, switching management companies, it can be done at any time, but it can be very disruptive. And it's not that you shouldn't if it's warranted, but seeing if the relationship can be salvaged or improved or made more efficient should, in my estimation, should always be the first course of business. There's a reason this company was hired. How do you make this work? Beyond that, the need to do it in secret from the manager, I think often directors can overblow the risks of the manager knowing that the board is dissatisfied. And again, frank conversations need to take place. And if they're unsuccessful, sure, the board can meet in executive session without the manager present. There's nothing that says the manager legally must be at a meeting. There are risks of that, but there may be a necessity. None of this should happen until you've had these frank conversations to improve the relationship or see if things can be changed to make it work, in my estimation.
Yeah, and this is a very, very common question I get asked every probably once every other week or so. It is important. The frank conversation, in my experience, comes from at the beginning of the discussion about hiring the management company. So you need to front end all of this. Make sure the management company knows what you're expecting and sit down so that they're going to want to price it right. So that's important, and they want to get paid properly, and they want to do a good job. So lay those things out way in advance. It's a little bit like most people have had experience with either being an employee or managing employees or both. And you need to do the same thing with your management firm. Set expectations, have frequent conversations about how the performance, what's going on. And then don't surprise somebody one day and say, hey, look, we're going to get rid of you when they walk in the door, and it's a surprise, because that only creates a bad situation for everybody. So those are my 2 cents, and we are going to have that program a little later. I think it is very expensive to change in terms of time and energy, to change your management company. So you got to be very careful about that.
It's an important relationship. It's important enough to explore, can this relationship be made to work better? Or do we misunderstand what the relationship even is? Mm-hmm. So again, that's a great program, and John Clenny will do an excellent job in that. I would encourage people to attend that.
Mm-hmm. Okay, so I think we're going to be moving on now to, let me pull up my script here. I think we're finished with the question and answer session, and I do want to have my concluding remarks here. So I want to say thank you to John and Brian once again, and I want to say thank you for being a member of ECHO. If you are a member of ECHO, and here in 2022, this year, ECHO has planned more than 60 online events. In addition, we are offering vast arrays of resources for boards and HOA members, including personalized guidance on challenging issues and a series of educational programs. Please join to help sustain ECHO. If you are not an ECHO member, please consider membership. It's the oldest statewide association advocating for better communities and well-informed HOA boards and homeowners. To do so, simply visit our website at echo-ca.org and click on the membership tab. Also, we have organized a new board members club. It's an exclusive club for ECHO members who serve or have served on the board of directors. It is exclusive to that cohort, so board members only. This group is led by 2 former volunteer HOA board members, Miguel Sanchez and Tom Connolly. They are wonderful, experienced leaders. Please click on the sign-up sheet in the packet or email Patty Curzet, PKURZET@echo-ca.org to become a member of this exclusive club. That concludes our planned program for today. Thank you again, John and Brian, for your informative presentation. And again, thank you to our sponsors who have made this broadcast available to everyone. And of course, thank you to all of you who participated in this investment in building better communities and helping our communities grow.